All right. Hi, everyone. This is Kurt Varone,
And Brad Pinsky.
and we're here for another edition of File Law Roundup for January 5th of 2026. Welcome, 2026.
Happy New Year, everybody.
Yeah.
Yeah.
Go ahead, Brad.
Okay, so we're going to start in Massachusetts, where we have a Boston firefighter who filed a suit. It's funny, I just won one of these, so I'll talk a little bit, in respect to this. But he files a suit seeking an injunction to stop discipline, and he was being disciplined, obviously. So he says, "Okay, I want an injunction, right? An order of the court forcing Boston to stop disciplining him." And so he files this emergency motion. My guess is, Kurt, I think you know whether he's got an attorney. I assume he does not on this.
I don't believe he does. He's filed a number of different lawsuits. I've got 13 entries of different cases with him since 2020. So he's a pretty
Right.
active uh, fire law participant.
Filling up your database. Well, he should get an attorney because he made a couple of errors, but on the same day he seeks an injunction, the city issues its disciplinary decision. So at the base level trial court, the judge denies the injunctive relief. He appeals it, and I'm always impressed when people without attorneys can appeal because appealing is so difficult usually. But nonetheless, he loses here. First, the appeals court says, listen, the trial court judge was correct, did not abuse his discretion in denying the injunction, and in fact dismissed the whole complaint.
Mhm.
But and the lawsuit filed, the court notes, you kind of messed up because the only relief you sought was the stay of disciplinary seatings, not the reversal of anything, etc. And the
That's the
court,
pro se. That's the pro
yeah,
se era, you
and he
know?
should have waited because the court also notes, and you and I have talked about this issue a number of times in the last month or two, and two, I think, that you have to exhaust your administrative remedies. You have to go through the full administrative process, and here he did not. And the court even emphasizes how important that is, just as you and I did last month, just as you and I did the month before that. You cannot skip your internal appeals process. If you do, you lose, even if you have the greatest case ever. He jumped the gun. Not going to happen. Um,
Brad, I got to tell you, I think now you just pointed out something, and I hadn't really put this in mind. What I did was I ran his name through Lexis, and that shows me all the cases that he's filed. And let me just go back. I just pulled it up over here. He filed one, I believe the one we're talking about was filed on February 12th. Okay. That was filed originally in Mass Superior Court for Suffolk County against the Boston Fire Department. It looks like he filed a second suit on February 26th. It's got a different case
wow.
number. Um, oh, that's the appeals court case. So I apologize. Okay, so here's what we got. He filed the initial suit on January 3rd. No, I'm sorry, that's January 13th of 2023. So no, he
A lot of
filed
suits.
the original case on February 12th. Apparently, he must have got a quick exit. And so on February 26th, he filed the appeal that they just decided. Then there was another appeal filed on March 7th. Okay. Um, and then the next one was an appeal, I suppose, um, of the against the Mass Civil Service Commission. That was filed on March 10th. Then he filed a suit against the City Retirement Board
Jesus.
on March 19th. Okay. Then there's another appeal, and I'm not sure of what case it was. It's not clear from the what I've been able to gather. On April 7th, he appealed that up to the Mass Court of Appeals. Then he filed a suit in federal court on April 22nd, alleging, various civil rights violations. Then he filed an appeal of that case uh, on September 29th to the U.S. First Circuit. So I'm assuming the district court in Mass dismissed it. Then we've got a second appeal to the U.S. Circuit Court, First Circuit, on October 31st, and then a more recent suit against the Mass Civil Service Commission on December 5th of 2025. So
Jesus.
he likes courts. We know that, and but this spinning of the wheels here is probably in related to his lack of an attorney, and having to do it yourself. You try something, you make a mistake. You try something, you make a mistake.
And I'll make a prediction. Courts are very tolerant of pro se, individuals, because, the law is supposed to be open to the common person, but it's
Right.
not. Let's be fair. It is so complicated to do this stuff on your own. But
It
so
is.
they're
It's incredibly, yeah.
right. Yeah. So they're very lenient. But after a while, judges get pissed off of wasting judicial resources and
Yeah.
start issuing contempt orders that say, if you file one more suit on this topic, we're going to hold you in contempt.
Well,
So
and there's one thing even beyond that, which is the vexatious litigator designation. And once you're designated as a vexatious litigator, and I've seen it's got to be 10 or more. The latest that I've seen,
Pretty
there's
close.
actually been some people who've been cited as being a vexatious litigator
Wow.
for less than 10, and the courts have said no, it's got to be at least 10. But once you hit that magic number, whatever it is for that jurisdiction, because federal and state and districts and everything, they're all a little bit different. But once you get designated as a vexatious litigator, you can't file suits anymore. What you have to do is schedule a meeting with the judge.
Yep.
At the judge's convenience. The judge will meet with you, you review it, and the judge will either say, yes, you can, or no, you can't. And that's a very serious, consequence of filing repeated lawsuits. So just something that, folks need to be aware of.
He's getting there.
Yeah.
Okay, to the case, which I think is the most interesting. I was furious when I read it. So when I read your description of it, so then I went to the complaint to see how the heck they won. So I'm we'll talk about this in detail now. So we're going to Pennsylvania, where we have a court that an appeals court affirmed an order that required a fire company to turn over all its apparatus. Now, I'm going to be very fact specific here on what happened. Some of it, I don't understand why the fire company was upset, but we'll talk about that. But for those who haven't read this yet, it ends up with a big, big contempt order. So this is interesting. So we have a township, which I don't truly understand why the fire company was opposed to this, but the township had a taxing district or tax approved for fire protection, and as part of another ordinance, put itself in charge, basically, of contracting and arranging for fire protection. So I'm not totally understanding why the fire company got upset. And I'd love to hear from them, right? If they want to tell us what they were so upset about, I'd love to hear it. But the fire company tells the town, we're not responding to your town anymore, and says we're only going to mutual aid. So that's the background, which, drops the gauntlet, so to speak. The town responds with saying, well, good, give us everything back. And their rationale, which was upheld in the court, but I'll get more detailed, was that, look, you use town taxpayer money to buy all of this stuff. We even co-signed a note. Apparently, in the facts, nothing was titled to anybody, which with fire trucks, we know you get a certificate of origin, right? But there was no titling, and I'll talk about that in a minute. But so the town goes on and says
they were titled in the name of the fire company, not.
Oh, I
titled
thought the complaint noted that, or the lawsuit decision notes that they were not titled. The two vehicles that were given to them were in their name.
Right.
And the court notes.
How do you register them without a title? It's got to be titled, right?
Well, except custom vehicles, Pierce, things like that don't come with titles. They come with a certificate of origin.
But I mean, when you go to get your fire plates, Rhode Island, we have fire apparatus plates. When you get them, you've got to
register them.
You've got to show where you got it from.
Right. But there's no actual title, and that's what, courts have used. In any event, we'll talk more about that. So the town gets a decision after a 2-day trial from the trial court saying, yeah, you get everything except 2 vehicles, which are definitely titled, not only titled in the company's name, but they were purchased only with those with fire company private
Yes.
funds, not with the
Yeah.
town monies. But I'm going to stop here and explain why I was initially furious about this decision, because I hate this phrase, though I use it too, taxpayer money. Wait a
Mhm.
minute. Yes, it is taxpayer money when you raise it from the coffers, right? From the tax coffers. But the moment you contract with anybody, garbage, ambulance, fire, or the moment you pay a salary to your clerk, your treasurer, to the mayor, to the supervisor, it is no longer taxpayer money. Otherwise, as I sometimes facetiously say, good town supervisor, city mayor, whatever, manager, your house belongs to the taxpayers because you bought it with your salary, which was derived from taxpayer funding. So that theory, in my mind, is why I was initially very upset with this decision. So, how does the court get there to say, listen, this taxpayer money from a fire company needs to be, and equipment needs to be placed in what they did, a constructive trust, right? Where it's safeguarded from the fire company spending it or selling their equipment or getting rid of it. How did the court get there? And they do that through what I presume up until now, very state specific. And this is not from the model not for profit corporation law, meaning I haven't seen this in a lot of states, but it says here's what their section 5547 says of nonprofit corporation law. Every nonprofit corporation incorporated for a charitable purpose may take, receive, and hold such real and personal property as may be given, devised to, or otherwise vested in the corporation in trust for the purpose or purposes set forth in its articles. Now, there is very similar language in the model not-for-profit corporation law, but it doesn't necessarily use the words in trust. But I'm still trying to track that down, just didn't have time before the show. So how does the judge get there to say, well, you got to put it all in constructive trust? That's how. If you are in Pennsylvania, anyway, if you are a not-for-profit and you have what originated as taxpayer money, and I would argue it doesn't matter where the money came from, even donated money, right? That's why I didn't necessarily understand why the judge went the other way on the trucks, but it doesn't matter where the money came from. It's held in trust for the taxpayers. And so they took everything, the judge took everything and put it basically in trust, meaning you can't sell it. It belongs to the town now. Now, I will note to you in a federal court case, New Windsor, doing this from memory, New Windsor Volunteer Ambulance Company versus Town of Windsor or New Windsor, had a very similar issue. And what the court looked at was many things, but specifically the titles, and said, who are the, in that case, ambulances titled to? And they said titling's 99% of the law. And in that case, the federal court said it all belongs to the ambulance company. It doesn't matter that it came from town funds. So I couldn't find, why does one court go one way and another? How do I keep them together? And it's this section of the not-for-profit corporation law that did it.
That's interesting. I went in an entirely different area here, and no, seriously, I was looking at the politics of it, and I don't know about this particular community. I have no connection to them. I don't know anything about it, but I know many volunteer fire companies in Pennsylvania have various means to raise funds. It could be a bar, it could be a restaurant, it could be bingo, other forms of gaming, and different things. So there's a lot of different ways. I didn't see any discussion of that. And I do wonder, getting to your point, how exactly would something like that impact a decision? That was sort of question number one. Question number two,
I
which
can answer that one when we're ready.
is pure local politics. And again, I have no knowledge about what happened in this particular case, but I do know that sometimes somebody's a volunteer firefighter, and for whatever reason, they're no longer a volunteer firefighter, and they've got animosity toward the people who are still volunteer firefighters, okay? And they get elected, okay? And they start trying to take control over the volunteer fire company.
Yep.
And the fire company is like, F you, we are not going to cooperate with whatever it is you think you're doing as an elected official. And
Yep.
now you find yourself in this situation. And it seems to me like there was some brinkmanship that may have been going on here. Now, whether or not it was legitimate concern about how the fire company was spending money, or whether it was some sort of, local politics that was driving this, but there was pretty clearly some brinkmanship that did not work out well for the fire company. And
And it
that's
never
that's how
does.
I kind of looked at it.
Yeah. So look, I've had a number of these. One of them, which I lost badly, sort of, and I want to talk about why, was in Monroe County, New York, near Rochester. And I had this. The town had a contract, in this case, with a fire department and said, oh, we get everything back. And I said, you can't get everything back. It's ours. And, it doesn't work that way. And we got into a million legal arguments, and I was right on the legal argument, but I lost because of exactly that. The judge says to me in chambers, he said, you don't really think I can just take a bunch of stuff bought with town money and give it to a fire department who's not going to use it for the benefit of the town? I said, Judge, what law does that violate? He's like, I don't care. and that, you're right. So he's like, so figure it out. But that, you're 100% right. That's it. It's the guttural, right? I'm not going to allow that to happen. Now, in this case, the attorney or the judge or whoever pulled out that section of law was, pretty on top of things. But, I looked again, it's like section 202 of New York's law, which very closely models the model not-for-profit corporation law, doesn't even have the word trust in it. Right? They don't do, a lot of states don't do that, but PA did, and the lawyer caught it, and it was a great argument in truth. I mean, that's,
Yeah, well, it's certainly IRS implications as well. If assuming that you are a 501c3, the IRS is not going to let you use that money. Now, as long as it's for charitable, it doesn't say it has to be charitable within that community, but it still needs to be. And I would assume as long as you're responding on mutual aid, which is really kind of bizarre to me. Like I don't know. It's
well, that's where we started. I don't understand why the fire company got so upset about this.
Yeah. Well, you're not going to tell me what we're going to do with our money, I guess. So.
Yeah. Anyway, bad choice by the fire company, but I'd love to hear what their motivation was if they want to harass you.
I'll bet there's a pretty interesting backstory.
Oh, I'm sure there is, and I bet there was tons of discussion before this happened, and but if the town had the right to do it. So, caution to everybody. Courts do in the whole brinkmanship argument, because that's what always wins the day. I don't care what the law is. It's whether law's in your favor like it was here or not in your favor like, other places. The issue is, come on, it's taxpayer money, and we're not going to allow you to take it from us. That's what's going to win. Okay, let's go to California. We have a deputy fire chief files a disability harassment lawsuit. Interestingly, not a race lawsuit, and I don't 100% understand the allegations, but I'll go through what we have. So he's in the Sacramento Metro Fire District.
Metro, they call it.
Okay, that makes sense because you can't say it. So he's alleging again disability-based harassment. He also claims that when he reported something, which we'll get into, to HR, they didn't investigate it or didn't do a neutral investigation, which always comes up. And they failed to prevent the discrimination, all in violation of the California Fair Employment and Housing Act, FEHA. We see this raised a gazillion times, right? I'm imagining that's a very prevalent statute in your database. In any event, so the deputy fire chief began in 2003, so he's been there for a long time. He went through a bunch of promotions, and then this all started in 2023 when he's diagnosed with PTSD and severe alcoholic use disorder. Now, I want to stop for a moment. We have a ADA or disability webinar coming up in, I think, March. Where we will discuss the issue I'm about to talk about. But if you are a continuing user, and I don't know whether he is or isn't, but if you are a continuing user of drugs or alcohol, then you do not have a disability that is protected under the ADA or the Rehab Act. I can't necessarily say about California, but I'm imagining it models the same type of
If anything,
language.
it's stricter than the ADA, if anything. Yeah.
Right. So you can't be a user, right? You could say, oh, I'm addicted, I have a disability. Well, that's great, but you have to be not using.
Mhm.
Otherwise, you're violating, right, a lot of other laws, like can't be drunk or whatever. And the issue here, before I get there, they allege the fire chief who was discriminating really believed, and I'll share his comment, really believed that no, the PTSD was a excuse for the alcoholism and that the alcoholism came first, right? Not that the PTSD caused the alcoholism, but instead you have an alcohol, the fire chief allegedly believed that the alcohol was the real issue. And, oh, well, the reason I'm an alcoholic is because of the PTSD. And in fact, part of the complaint alleges that the fire chief made this derogatory comment. And that belief is what led to all of these issues. So in 2023, the deputy chief began experiencing some distress and anxiety. He began to drink. They call it self-medicate, but he began to drink. And in 24, he was diagnosed with PTSD officially. The PTSD diagnosis, at least according to one medical individual, was related to his service. He files a comp claim for the PTSD and severe alcoholic disorder. He then says after the diagnosis became known that the conduct of the fire chief changed significantly, and he uses a phrase, and now I've explained what he was saying, allegedly uses a phrase, another alcoholic, let me guess, they're going to file for PTSD claims. Now, I'm assuming the reason he may have said that, if he said that, was maybe this is common in that department. I don't know whether, is that a common, I mean, I haven't seen this before where somebody's, and I'm not saying it doesn't happen, where somebody is an alcoholic, but then says, oh, PTSD, and tries to claim, that the chicken before the egg is the PTSD, not the alcoholism.
Well, in my experience, it happens, and I consider it's sort of muddying the waters, so it's not clear, are you picking on me because of my workers' comp related PTSD, my job related disability, or are you picking on me because I was trying to medicate myself with it? And therefore, if you make light of any of those or either of those, you're discriminating against me. So I think I've seen it made, in real life more so than I've seen in cases. So.
Yeah, and so that's the suit, and it's going to be a question. I mean, I have legal concerns, right? The legal question is, are you still using? If you're still an alcoholic,
Well, and your ability to perform the essential functions, and that's I'm sure you're going to talk about that. But I mean, if the as a result of either your PTSD or the alcohol or a combination of both, you're not able to perform the essential functions. That's a problem in and of itself. Now, from the chief's perspective, if he is able to perform the essential functions, now you've got some splaining to do.
right, right.
So,
And you
this,
better be careful because what a chief might say, I've learned this the hard way sitting in on an interview years ago. And the chief says, I really feel badly for you. How long have you had? I mean, it wasn't alcohol in this case, but I'll give the line of questioning. Oh, I'm sorry. How long have you been, having the alcohol problem? And the guy's like, oh, chief, it's been years. He's like, my God, how often are you drunk? Or intoxicated? And the guy said, every day. I can't get past a day. And what happens? He gets fired. You were drinking on duty. And they admit to this. So that's part of the problem that happens in some of these. So you have an alcohol problem. Were you drunk on duty?
there's one other thing that it was confusing to me in terms of the way that it was explained in the complaint. But he says that he is Mr. Bailey, another Mr. Bailey this week, but Mr. Bailey, Chief Bailey, says that he was the deputy chief of administration, which in my experience,
Over this, right?
that's a four bugle position. Okay. And he says that he voluntarily submitted for a demotion, which to me would mean now you're down to a three bugle position, which many departments would call an assistant chief. Some departments call the four bugle position assistant chief, and the deputy is down below it. But however it is, he's a four bugle. He requests a demotion down to three bugle. And as I read it, at least as I can see it, he was actually demoted down to battalion chief, which is a two bugle position. So is that sort of the crux of it, that he said, okay, I'll take the, and I'm not sure what the assistant chief would be, a shift commander or, some lower ranking chief, but is the crux of the problem that he voluntarily agreed to go down a rank and he was actually demoted two ranks? Is that part of it? I may be misreading it, but I was trying to kind of work through the titles that they used in the complaint, as explained in the complaint.
Right. Hard to figure out, but it is an interesting issue. I look at it as broader. And again, we don't know the truth. It's just a lawsuit. But I look at these things as broader than one department, meaning, look, mental health issues in the fire service are a big deal, right? We we go to calls. I watched the Swiss fire, right, the other day, and I'm thinking of you the whole time with Station. We go to these calls that you can't mentally prepare yourself for. You just
try
can't.
not to even think about them.
Right. And
So
then
horrific,
they come
but
back, whether it's days, months, or years later, and they start causing issues because they've been suppressed. And we want to be understanding in the fire service, right? We do. And look, people who get depressed or have PTSD will turn to alcohol or drugs or hopefully counseling and whatever. But so the fire service is hard. We got to treat our people with compassion, but on the other hand, we can't tolerate being drunk on duty if that's the case. We can't. There's certain things we can't, and then that's not the allegation here, right? We don't know whether it's drunk on duty or not. I'm not saying that, but it's a hard balancing test.
Yeah.
And I think the answer is things like the FMLA, right? We're going to give you 26 weeks unpaid or 12 weeks unpaid leave, maybe something else in the CBA or an employment manual or some, employee assistance program, EAP. We do something to help, and you got some time to get yourself better. But it's a hard, I get everybody who's in a hard position. What do you do with this?
Yeah, it's hard. It also can lend itself to being applied in situations it wasn't intended to be applied to by creative attorneys. Let's face it, and that can happen as well. But I still am a little perplexed by he voluntarily agreed to a demotion. All right. So now he could say, well, it was the equivalent of constructive discharge or constructive termination, that he was really pressured into it. But then if he, in addition to saying, okay, yeah, I agree to go down to a three bugle, he was actually demoted again down below it. Again, I think that could be the crux of what his damages anyway, and proof of, harassing intent by the chief. So I don't know. We'll see. Another one of those. We'll wait and see.
Yep, exactly. Okay, so now we got two more. We're going to go to, we have a former Cambria, California chief. This is like a little better than a nuisance settlement, but there's a settlement, $200,000. The insurance company paid it, which is why we know it's kind of like a nuisance settlement, or just, because it's going to, the insurance company feels maybe there's some chance of wrong, but we certainly have a chance of losing, and win or lose, we're going to lose a lot of money. So they paid out $150,000 in damage, so to speak, and $50,000 for attorney's fees, which is not usual, frankly. Usually the insurance company's like, we're going to pay X dollars, and you settle up with your attorney however you want. But nonetheless, we just have a settlement of a suit. We don't know much about it. No one admitted wrongdoing. The short of what we know is there was a 5-year contract, and he's terminated after the first year or year and a half or so. I don't know if this was a breach of contract suit, but it was a 40-page complaint. So I imagine it's everything under the sun. They alleged retaliatory practices, racial discrimination, sexual harassment, violation of certain codes, government codes, due process violations. He claims he was the only African American employee of the district and the first African American fire chief. I don't know. He alleges his complaint stems from a formal grievance back in 23. There was a lot of improper conduct, of 40 pages worth of improper conduct.
Yeah, and I think at the heart of it was that issue of he had a contract, but it's supposedly under law it had to be approved by the council, the district, and it was never approved. So that's what they used to get him out of yes, we signed it. Yes, you signed it, but it says right in it, it's got to be approved, and it was never approved. So therefore, we're going to terminate it.
And look, in my experience, $150,000 for a payout is not small pennies, right? It's not like the normal 20, 30,000 go away. So they must have found something fairly credible that they thought they could lose on to justify that amount of money, 200,000 total.
Yeah.
So anyway, okay. Lastly, and I find this really interesting. All these things. I don't deal with this as much, but in Texas, apparently, the collective bargaining is not the presumed right. Right, you have to petition for it.
It's not. I think the best way to think about it is like in a state like New York or Rhode Island, firefighters have a state law that authorizes or empowers them to engage in collective bargaining. So it's a state law issue. Texas doesn't have a state law. It's really on a local level, or the state laws allow the municipalities to make a decision on collective bargaining.
Right. And the way you do it is you get a petition of a certain number of signatures. In this case, just like New York, this must be a common standard. You need 5% of the people who voted in the last election, last November 24 election in this case. So they got the would-be union people, the plaintiffs, said they got more than enough signatures, and the city said no, that they didn't. So they've now sued. I had this exact suit. Not over a CBA. We reported on it in Oswego County, New York, where I had a petition thrown out for 15 different things. It was wrong. But it's the issue is going to be they're going to have to go name by name, and they're going to have to see whether the petition should have been certified or not. I mean, that's how this is going to resolve. I'm hoping that the city did a true review of the signatures. But, it doesn't take much to get. It's probably a registered voter, right? And I'm assuming they have to be a registered voter, and you got to get the right number. So if you got a voter list, registration list, it shouldn't be that hard.
Well, unless the elected officials don't want to see it get on the ballot, and then they start saying, "Oh yeah, that's not enough," and they don't really have any backup, and then you're basically forced to take them to court, where now they're going to have to say on each of those ones that they say is not valid, why did you say this one was valid? And if the court says, no, there's 2,200?
Yep.
That's going to be the end of it.
And I would want to see the notes. I would want to see the town's or the city's notes, because I would be suing for bad faith, almost like an insurance bad faith claim. I would be suing for attorney's fees and sanctions, contempt, everything. If there are no notes that show check marks by each person that they, right? And they better have kept them. But I'm guessing if this is true, you're not going to see anything like that produced.
Yeah. I was working on my discipline book, the book that goes along with my the Managing Disciplinary Challenges class. I've been updating it. And Arkansas, I was just working on it this morning, but Arkansas has a state law for firefighter Bill of Rights. But like this law, it has to be adopted at the local level. And I suppose that those types of things happen at the state legislature when someone says, here's a firefighter Bill of Rights, or here's a collective bargaining law for firefighters. And, oh, no, we can't. Well, how about we leave it up to the locals, okay?
Right.
Which I think is a stopgap measure. But at some point, the people who want to see collective bargaining for firefighters need to go to the state legislature and say, enough is enough. Let's let's get this enacted like all these other states that have collective bargaining for firefighters. Same thing with the Firefighter Bill of Rights. It's all well and nice to leave this up to the locals, but at some point, let's face it, it's politics, and we've got to lobby for the things that are in our interests.
Yep.
And I think that's the solution to
And
cases
it's
like
not a
this.
voter decision on an individual basis. What do they know? Somebody's coming to your door. Hi, ma'am. Hi, sir. We're the fire department. We'd like you to help us protect our rights of money and fair negotiations and all this stuff. Would you sign this to allow us to have a union? Come on, that's a political decision that should be made, not a resident decision like that.
Yeah.
So,
So,
okay, that
all
is it
right.
for the week.
Yeah, that's it. That's it for another edition of File Law Roundup, our first one for 2026. So, 2026, at least the first volley here is in the books.
Yep.
And if you haven't, first of all, if you're still listening, thank you for hanging in there till the very end. Please click like and subscribe. We really can use the support. It really helps us with our algorithm. We're continuing to grow, and that makes it worthwhile for the effort that Brad and I put in here. So we appreciate your support. And that'll do it for another edition of